The judiciary should be viewed as an institution that is there for everybody. It is a place where all of us can approach to seek justice where we feel our rights are threatened or violated. It is a place where we have a team that is committed to serving them, to ensure that the delivery of justice is timely, is fair, is not viewed as corrupt.
The courts in Kenya operate at two levels, superior and subordinate courts. Superior courts comprise the Supreme Court, Court of Appeal, High Court, Employment and Labor Relations Court, and the Environment and Land Court. Subordinate courts, on the other hand, include the Magistrates' Courts, Qadhi's Courts, Court-Martial, and any other court or tribunal established by an Act of Parliament. A magistrate's court has the authority to hear all criminal cases except murder, treason, and crimes under international criminal law. It has the authority to hear all civil cases except those limited by statute. Qadhi's courts have authority to hear cases on marriage, divorce, and inheritance where those involved are Muslims. The court-martial hears cases involving people serving in the military and they are established under the Armed Forces Act. Tribunals are bodies established by Acts of Parliament to exercise judicial or quasi-judicial functions. They supplement ordinary courts in the administration of justice, but they do not have penal jurisdiction. The High Court has jurisdiction to hear all criminal and civil cases as well as appeals from the lower courts. The Court of Appeal hears cases arising from appeals over the decisions of the High Court as well as any other court or tribunal. Kenya's apex court, the Supreme Court, has exclusive original jurisdiction to hear and determine disputes relating to presidential elections arising under Article 140 of the Constitution. It has appellate jurisdiction to hear and determine appeals from the Court of Appeal and any other court or tribunal as prescribed by national legislation. It hears and determines matters involving the interpretation or application of the Constitution and matters of general public importance. The Supreme Court has the right to render advisory opinion at the request of the national government, any state organ, or any county government with respect to any matter concerning county government. It can also determine the validity of a declaration of a state of emergency, an extension of such declaration, or any legislation enacted in consequence of a declaration of a state of emergency. Easy access to justice has entailed the opening up of more high courts and the increase in the number of judicial officers.
Kenyans who want to reach a magistrate court or a high court or court of appeal can reach it with ease. Take for instance the distance between Garissa and Mandera, something like 800 kilometers. All the people from what was called Northeastern Province would come to Meru for the determination of their cases. But now we've set up a high court in Garissa, we've set up a high court in Lodwar, the far Rift Valley. We set up a high court in Kapenguria, just to ease on distances.
We are now moving to counties, opening courts, high courts in counties. Access to justice now is slowly by slowly becoming nearer. People are no longer spending thousands of shillings, traveling hundreds of kilometers to reach our court stations.
Between 2010 and 2016, high court stations rose from 14 to 34, and the plan is to have a high court station in each of the 47 counties. The Court of Appeal has been decentralized and new stations established in Kisumu, Nyeri and Mombasa, in addition to Nairobi. In the first 5 years of judiciary transformation, the number of judges rose from 53 to 136, while magistrates and qadis are over 470 in number.